Well, thank you, Pam, and good afternoon, everybody. And thank you for joining us. The topic today is key developments in UK competition law in 2020. We have a fantastic panel who, between them, bear quite a lot of responsibility for those developments. Now, they cover both the claimant side and the defendant side, litigation and non-litigation. So we have a lot of interesting topics, and what we're going to do is a brief presentation of 5, maybe 10 minutes for each speaker covering a couple of things, and then we'll try and have a discussion insofar as this format obviously makes that a little more difficult than would otherwise be the case. Please do post questions though in the Q&A and we will do our best to deal with them. Now, before we start, I want to introduce the panel. First, we have Claire Jeffs. She is co-chair of the Slaughter and May Competition Group and one of the leading merger lawyers in London. She's not just a merger lawyer though, she's been helping Google out with some rather tasty antitrust problems recently. Next, we're going to hear from Mark Sampson. He is the joint head of Freshfield's Global Antitrust Group, as well as a litigation partner. And I hope he'll take it as a compliment when I say he is an out-and-out litigator, among other things. Caroline Edwards is a partner in the Travers Smith Dispute Resolution Department and a member of the firm's international board. She is one of the field marshals in the war that is known as the trucks litigation. Unfortunately for me, she is on the other side in that one. But thankfully, I have Ed Coulson on my side. He's a partner in the BCLP competition litigation practice and is leading the fight for a number of claimants in the trucks case. And then finally, last but not least, Grant Saggers of NERA is going to provide the economic perspective. Grant is a director of NERA and has acted in a lot of heavy competition cases. Indeed, he is also on the side of the angels in trucks. So with that, we're going to start, please, with Claire, who's going to talk briefly, I'm sure, about cartel defense strategy before regulators, and then something on the ever-vexing subject of standard of proof for a decision and standard of review on appeal. Claire.
Thank you, Tim, and good afternoon, everybody. Yes, I wanted to offer some thoughts on what's happening on the public law enforcement side of life, in other words, before the regulators. And I'll start with cartels and then antitrust more generally, and if I'm allowed, a couple of minutes on mergers at the end. So starting with cartels, I mean, as we all know, most of the big cases historically have started in Brussels with a cartel investigation by the European Commission, although of course with Brexit we're about to see parallel enforcement by the CMA. Now the bottom line is EC cartel case law is very favourable to the regulators. So these are object cases, no requirement to show anti-competitive effects at the administrative stage. The notions of anti-competitive agreement and single continuing infringement are very broad indeed. So in many cases that drives you down a path of internal investigation, leniency race, and then ultimately settlement. And as we all know, although the settlement discount is only 10% formally, in practice, the European Commission have a high art of persuading you to come in by promising to be reasonable on scope, duration, and so on, and effects in settlement. So they try to get you to come in. So I think an interesting question is, how is the burgeoning private damages industry that many of my co-panelists are so active in affecting all of that? And, you know, there's been quite a conversation about, will that affect the willingness of companies to go in for leniency and settle? And I think from my perspective, you know, there's some evidence of that. There is talk that the overall number of leniency applications is down, although you can't really show cause and effect there. And we also see hybrid settlements where not all companies are willing to settle. But at the same time, at least from where I'm sitting, leniency is still alive and well, and it's not just me, there's plenty of other firms involved in that. So it seems like, you know, there is a continued pipeline of cases to come. But I think as a practical matter, what really does matter, and I think we can all agree on this, is you need to be very careful about the submissions and admissions you make during the administrative stage on questions of scope and duration and certainly effects. And that will often have to be done at speed in the context of a leniency race. And so, this is where we as kind of public side lawyers need to be alive to what's going on the private damages side. Moving on to the non-cartel side of antitrust enforcement, so General 101, 102, Chapter 1, Chapter 2 cases beyond cartels, well, that's when life gets even more complicated from my perspective, because there the regulator does need to show anti-competitive effects, even at the administrative stage. And the point I wanted to mention here is I find it really striking that after all these years, decades of competition law in Europe, there are still really big issues of law that are in dispute in these cases at the administrative stage. So, what degree of probability of anti-competitive effects does the regulator need to show to make an infringement finding? And, the EC are still clinging on that it's capability, not likelihood, even though the General Court and the Court of Justice have told us that they are the same. So that is interesting. Even more so, they will say that it only has to be potential effects, not actual effects, even when an infringement has been going on for years. Alleged infringement, and even despite some of the case law on that. And then when you get to 102, it gets even more complicated. We had the Intel judgment, which is very interesting, but we're now in a period where we're trying to work out, of course, what that means. And there's only about 4 or 5 paragraphs in that judgment that are really on point. And so there are still many debates about the scope of any remaining per se rule under 102, the role of the as sufficient competitor test. And, these are really complex legal, factual, economic issues, especially in these fast moving technology markets, which is so much the focus under 102, Chapter 2. And I think that whole debate is about to bleed over into the regulatory arena with the new digital regulation that is in the process of being established. Just wanted to think also about the standard of review on appeal in antitrust cases. I think quite an interesting juxtaposition between the position in Europe and the UK. So in Luxembourg, the General Court, I would say, is not particularly interventionist. It's a manifest error test, but even they have clipped the Commission's wings a bit in cases like Carte Bancaire, and Intel, as I've already mentioned, basically saying, Commission, you need to do better on effects. And then we also have cases like Servier and Kitschker, where they said, you don't need to show actual effects, but you do need to take account of what has been happening if your alleged infringement has been going on for years, which I think is helpful. On the CAT side, of course, it's full merits appeal at the moment. And the CMA are vociferous on the subject that it is too hard for them on appeal, because we now have these very lengthy hearings, witness evidence, debates about admissibility of new evidence. And so the CMA are now saying there needs to be legislative reform on the standard of review, and maybe the UK is going to move to the EC manifest error test, which is all very interesting. Tim, can I carry on for 2 minutes on mergers? Mergers is a very interesting world as well. I mean, it is now standard for merger decisions to be dozens, if not hundreds, and I'm starting to think thousands of pages long, including annexes. I mean, this is getting really, really heavy. The EC are pretty interventionist. The CMA, as many of you will know, I think are now very interventionist, and deliberately so. There is a view that too many mergers have been allowed to proceed, especially in certain technology markets. And I think the statistics are quite revealing about the proportion of UK cases that are now going to phase 2 and ultimately being prohibited. In that context, of course, there's a lot of debate about the standard of proof, again, for prohibition and in some cases for clearance. And the CMA are saying that we need to be more flexible on the legal and evidential standards to prevent problematic deals happening, especially in the technology sector. And we're likely to see legislative change on that as well. And again, that's going to be very interesting. Again, on the standard of review on appeal or on judicial review in the UK on the merger side, again, there's quite an interesting juxtaposition, I think, in terms of what's happened over the last year or so in Luxembourg versus the CAT. So the General Court has overturned a couple of European Commission decisions and been quite harsh, I think, on the European Commission, most obviously in the CK Telecoms case, which I know Mark's colleagues were involved with, as was I for a third party. That's overturning the 023 UK prohibition decision. And there the General Court made really quite wide-ranging comments on the standard of proof and said there needs to be a strong probability of effectively anti-competitive effects in their merger jargon. And they were also extremely critical of the European Commission's reasoning, even on quite technical, factual matters. So that is very interesting, but now on appeal, of course, to the European Court, the Commission have appealed. By contrast, in the UK, I would say the CAT is really very deferential to the CMA. Now, partly that's a function of the fact it's judicial review under the Enterprise Act. But more broadly, they seem to be very deferential to the CMA's discretion to look at the evidence in the round to decide how much weight to give to any individual piece of evidence. And those phrases about in the round and weight appear with startling frequency in CMA decisions as a result. And but the CAT will still intervene if they believe there's a fundamental error to a failure to look at a key salient issue, and that's what happened on half an issue, I think, in Toby and also in JD Sports, where the CMA had failed to look at the impact of COVID on the merger, although the CMA is now appealing that, so we'll see what happens on appeal. So all of which to say, I think it's quite a febrile atmosphere on the merger side in the UK at the moment. We have a very interventionist regulator and a rather non-interventionist appeal tribunal. So it's going to be interesting to see how that unfolds. And, you know, more broadly to see how, you know, these different regulators and courts in different jurisdictions will continue to try to strike a balance, both on the antitrust side and the mergers side, between kind of the rights of the defence on the one hand, but on the other hand, the importance of administratability, and they would say the interests of consumers. So watch this space.
Claire, thank you. That was fantastically interesting. Let's split that into the two headings that you presented it under and start with the material about regulators and the approach to both cartels and antitrust more generally. Would anyone on the panel like to add any thought or comments on what Claire, or even question on what Claire has already said?
Tim, I just had Claire, I had a question really. I know Caroline is going to come on to talk about it more in detail, the judgment, but I just wondered, you were talking about admissions in the context of settlement processes, and I just wondered if you had any immediate reflections on, in the light of the abuse of process judgment in trucks, whether that was immediately an additional thing on the menu of considerations and how much bearing that has for you immediately.
Yeah, I think I'm still processing all of that, and you know, very much looking forward to hearing more about it. because I mean, obviously we do try to be very careful about what we agree during the EC process, but it is also a multi-party process, and one with a regulator wielding a pretty big stick. So I'll watch with interest.
Understandably non-committal, I would say. Anyone else? Is that you, Mark?
Sure. I was just going to engage with the point Claire made about whether immunity application volumes are down and what that says about the future, I suppose, of follow-on damages litigation as we work the way through the existing pipeline. It's absolutely right what Claire says, of course, that there is evidence that volumes are down in recent years at the Commission and also DOJ and other major agencies. And yet I struggle to believe that, despite the fact that tradespeople have been meeting in smoke-filled rooms for hundreds of years, that that's somehow all dried up. I've no doubt, I think the major corporates, some of the sort of recidivists of the last couple of decades have undoubtedly spent an awful lot more on compliance and tightened up efforts. And I think there will be some reduction there. But equally, I fear and I see from sort of experience these things that they're cyclical. And just as we had a spate of cases arising out of the last financial crisis, all the sort of financial instrument cases, I wouldn't be at all surprised if we had another series of cases arising out of the aftermath of COVID and some of the collaborative measures that have been taken, either in good faith but overstepping the line, or in some cases in bad faith by way of crisis cartel type behaviour. That I suspect will be investigated in the course of the next 12 months and beyond, and lead in due course to infringement decisions. So I wouldn't mind betting that 2 or 3 years from now we're looking at another wave, in the same way that we had with LIBOR and FX and Euribor and the other cases at the time, bonds and so on, and in the same way we had with auto parts. The other part of the phenomenon, of course, is that the agencies are increasingly going after behaviour that would have been considered more borderline before, so info exchange type cases. They don't always follow through to an infringement decision. The aviation insurance decision of the European Commission, which MLEX reported on this week, is an interesting case in point. They decided to close that one. But you do see an increasing number of investigations around that sort of borderline, cartel, info exchange, collaboration type conduct. My own view, maybe I'm just a sort of natural optimist, if optimistic is the right word for this, is that I think there will be another peak of enforcement in due course. It's not a sort of inexorable tail off.
Thank you. Shall we just move on then to Claire's other topic, which was very interesting, on the question of standards of review. And it strikes me, listening to Claire, that there are essentially two different problems that courts have to grapple with. There's primary fact, and then there's economic analysis. And all forms of competition and indeed merger cases throw up these problems to some degree. And what we see is a spectrum. So we have the CAT approach to penalty cases, which is truly full rehearing, live evidence, cross-examination, primary fact finding, and of course, generally an economist member on the panel as well. And one of the CAT's strengths is it's not afraid at all to get involved in detailed economic argument. Then in the middle, I would say, you have the Luxembourg approach, which is a sort of form of intense judicial review. Good luck trying to get any kind of live evidence heard in Luxembourg, and the court has contorted itself to convince itself it complies with Article 6 and the right to a fair trial, despite the quasi-criminal nature of antitrust penalties. But it definitely goes further than what an English common lawyer would regard as judicial review, even though there is this big area of deference on matters of economic judgment. And then I'm afraid last and least, in my opinion, is the Competition Tribunal approach to judicial review on mergers, which is very much what one might call classical judicial review. In other words, it's loaded with concepts like irrationality and very high on deference. And of course, judicial review is a process that's ideally suited for deciding true points of law, so a point of statutory construction or something of that kind. And the more it gets weighed down with economic type arguments, the more difficult it is. And I actually think that the tribunal does a fantastic job usually in dealing with these matters and doing its best to engage with that substance. But there is no getting away from the fact that judicial review is just the wrong tool if what you really want to do is engage with detailed matters of economic analysis, which ultimately are likely to involve questions of appraisal rather than black letter legal issues or bare questions of rationality. Now, Mark was talking about the cyclical nature of some aspects of what we do. And I think there's a cyclical issue that's coming to the fore at the moment, which is legislative change to standards of review. And as probably many people will be aware, the government is having a push at the moment on judicial review generally, no doubt with a view to finding ways to make itself less vulnerable to judicial review challenge. And we've heard this in the competition space really since the early days of the Competition Act. And I can think of at least 2 attempts at reform which were mooted and then faded away. But I wouldn't at all assume that will happen at the moment, given the more general political climate in terms of well, rule of law issues, I suppose one might say. So there's a little chairman's privilege being abused with some thoughts from me, but over to anyone else on the panel who wants to contribute on that. Any takers?
Well, Tim, just to echo, as an economist, the CAT is becoming so good at dealing with economic evidence in the various different cases, and the sort of acceleration even in the competition litigation of damages work, the sophistication of the analysis of the econometric evidence and whether certain data is necessary speaks to it being able to take on some of these more difficult economic issues. But I agree with you, it does slow it all down quite a lot, weigh it down, as you say. So that's, I think, the big challenge for both the CMA and the CAT to find the balance of how much detail the CAT can go into.
I think I'm very much agreeing with you, Grant. One of the things that the various people on this panel involved in the trucks case hopefully could agree on is it's very refreshing that the Competition Tribunal is completely receptive to the idea that econometrics is going to play a large part in these trials. And whilst we've had big arguments about disclosure, which might be touched on later, there's no dispute with the tribunal about whether highly detailed data is needed in order to do econometric analysis. The tribunal, I think, fully respects the need for that and understands the reason for it.
That's right.
Good. Anything else from anyone, and indeed anyone in the audience, before we move on to our next set of topics?
Just one quick thing, Tim. I would agree with what Claire noted about the recent trend of challenging merger decisions, and I think that's something we're going to see more of going forward, as we have a more assertive CMA, which is undoubtedly also taking tougher, harsher, and some might say more timely intervention decisions on procedural issues as well, with interim steps and so on. I think we're inevitably going to see an increase in clients of our respective firms considering the need to challenge those in the tribunal. And cases such as JD Sports, which was mentioned, which colleagues of mine did, is a really good case in point. So I do think for practitioners in this field, that is going to be a growing area of work in the years to come.
And Tim, I think that Justice Roth, in his opening comments, spoke about the fact that post-Brexit, there's going to be a number of phase 2 transactions that are going to be going through the CMA, and the strategic challenge of appeals against phase 2 decisions here in the UK, while the slower process of appeal on those sort of decisions in Europe. I think that you were saying that if there were 3 big judicial reviews of mergers every year, that would be a huge ask for the CAT going forward.
Good. Anything else from anybody before we move on? No? Well, thank you, Claire, for that very much indeed. It was really interesting. Next up is Mark, who is going to talk about, in his words, the battle for supremacy between the UK and the EU jurisdictions in damages claims. Mark.
I'm not sure they were my words originally, but I'm happy to talk about it. Here are a few thoughts on what is a big topic, and there's all sorts of limbs to it, and there's no magic in any one person's views, it strikes me, but here's a perspective, what it's worth, and perhaps to spark some discussion. How is the UK going to do as we move forward, as continuing to be a centre, preferred forum for competition litigation, competition damages actions? Clearly, the UK faces a particular challenge at the moment with the impending end to the EU exit implementation period. We're going to lose application of the Brussels regulation that's provided the jurisdictional basis for most competition damages claims over the last couple of decades. Future European Commission infringement decisions will cease to be formally binding on English courts, the tribunal. And of course, all the while, continental European regimes continue to evolve, both in further implementation of the Antitrust Damages Directive, and also because the systems continue to grapple with more cases there as well. So jurisdictions such as Germany and Spain offer undoubted advantages to claimants in some cases. They can be cheaper. They can certainly allow claimants to get to trial more quickly. And we've seen in recent cases that they could deliver a higher prospect of getting overcharge being assessed on a rough and ready basis, as in some of the recent Spanish trucks cases, or indeed the recent 30th of September judgment of the District Court in Dortmund to award a 15% overcharge based on generic and pretty much non-case specific considerations. And of course, continental collective proceedings regimes continue to develop, albeit from a starting point that lags behind the collective proceedings regime that we have in the UK. The Netherlands now has an opt-out class action regime to accompany its pre-existing opt-out collective settlements regime. The European Commission, of course, as people will know, has in the last few days last adopted the European Representative Actions Directive, which once it's published in the OJ in a couple of weeks' time, will then have to be implemented in EU member states by January 2023. Despite all of that, though, I remain optimistic as to the vitality and the future of the UK competition litigation system. I don't think it's blind faith. I think there are a number of good evidence-based reasons to consider that the UK is going to continue to be one of the leading, if not the leading venues within Europe for this litigation. And they're these. First, I think the UK courts will likely continue to take a relatively wide approach to jurisdiction. They always have done, including in cases that don't engage the Brussels regulation. Plenty of Russian oligarch litigation happens before the English courts, and not all just down to choice of law clauses, of course. We've previously, of course, seen the English courts take a wide approach to jurisdiction in the competition damages context, albeit under the Brussels regulation. So think of recent cases like Vattenfall, where the court took a pretty low threshold approach to what would amount to implementation of a cartel on the part of an English anchor defendant. And I think in the post-Brussels regulation environment, if anything, the common law jurisdictional gateways offer ample flexibility, arguably on some bases even more flexibility than the Brussels regulation, and don't seem to me to be anything resembling a showstopper. And of course, in due course, we might accede to Lugano Convention, which would align everything pretty much as is once again. But there are jurisdictional limits, and I think it's going to be interesting to see how those play out. Two instructive recent cases. The first is the recent 9th of November judgment of Mr. Justice Turner in the High Court in a non-competition case, actually, the Mariana Dam collapse case. That was a claim brought by a claimant law firm, PGMBM, on behalf of about 200,000 Brazilian individuals and institutions who are claiming damages from BHP for the Samarco dam collapse. The case was dismissed on various grounds, but the main one was that it was found to be an abusive process for the claim to proceed in England, when at the same time multiple related proceedings were ongoing in Brazil. Why is that relevant to us competition litigators? Well, because exactly those factors could apply in other cases. Most proximately, the same claimant law firms brought a cartel damages claim in the High Court here in London. It's all about Brazilian orange juice, and it's on behalf of a large group of Brazilian orange farmers who claim to have suffered loss due to conduct that was sanctioned and subject to a settlement decision by the Brazilian competition authority, CAGE, back in 2017. Why is that interesting? Well, there's an alleged UK anchor defendant, but very similar jurisdiction challenge issues arise. The conduct is entirely Brazilian. The entities are essentially all Brazilian as well. The infringement decision is Brazilian. And so that is rather a nice little test case, both of the doctrine just laid down in the Samarco Dam collapse case. And also, it's a little bellwether, isn't it? A little sort of canary in the cage for the status of European Commission infringement decisions in the post-Brexit world when they are no longer binding. Let's just for a second sort of skate over the fact that apparently the Brazilian settlement decision isn't even binding on courts in Brazil. But this question still arises as to what sort of status the English High Court will be prepared to give it, if indeed jurisdiction is established in England. So very, very interesting case. And you can contrast that with some of the struggles that claimants are having bringing their cases in other European jurisdictions. So yes, there's the recent Dortmund case I referred to, but on the other hand, in Germany, a number of the attempts to pursue some of the sort of bundling assigned claims models before the courts in Germany have hit the buffers because the courts there have not been persuaded that those mechanisms were lawful as a matter of German law and public policy. Similarly, very interesting recent judgment of the Amsterdam court in the Netherlands in a power cables follow-on damages claim. That was a claim brought against ABB and others on behalf of a series of Middle Eastern claimant entities. And they were relying on, or seeking to rely on, a very wide interpretation of the Court of Justice's judgment of Skanska in order to bring claims against sister companies of the infringers and the addressees in the Netherlands. And the Dutch court was having none of that. And in a recent judgment, 26th of November, has declined to take an undertaking-wide approach to establishing jurisdiction in light of Skanska. I think, by the way, an English court would probably have reached the same view, but what it does at least show is it's not like we're fighting a sort of unlevel playing field battle in jurisdictional terms with other EU jurisdictions. They're not throwing open the doors wider than we are. Here are a few other reasons why the UK might continue to pick up more than its fair share of competition litigation in Europe. The UK collective proceedings regime, obviously we're all waiting on the Merrick's judgment still, with a further delay after the very sad events of last week and the untimely death of Lord Kerr. There's no doubt though, whichever way that case goes and whatever the judgments, the collective proceedings regime is still something that sets this system apart from others around Europe. There isn't anything quite like it. And I say that even though, at least for opt-out actions, classes are limited to UK individuals. There is something about that regime which offers something much closer to North American style actions than is available anywhere else in Europe at the moment. And that will probably continue to be the case for quite some time. And third, the rollout of an implementation of the Antitrust Damages Directive around Europe is slow and it's incremental. And in many civil law jurisdictions, the court setup and the judicial system just isn't well tailored to building in, for example, large disclosure processes or having judges review detailed, hundreds of pages long econometric reports and agree-disagree statements and, all that sort of thing that there just isn't time for in their system with the docket of cases they have. And so there will continue to be comparative advantages to suing in the UK where there's a jurisdictional basis to do so. And indeed, there could be some positive advantages. Yes, we're going to have the issue of what status will be accorded to European Commission or other infringement decisions, at least ones that are handed down or issued post the end of this year. But firstly, it's going to be a long time to operating entirely in that new world because there's a long old pipeline of work in the meantime that will take years to work its way through the courts. And secondly, I'm sure other panel members have had this experience. I can't remember the last case I did that was alleged to be entirely follow-on. Pretty much every case we do has some standalone elements, whether it's a pre-cartel period, a post-cartel runoff period, whether it's umbrella sales, whether it's just some additional allegations which aren't covered by the four corners of the underlying infringement decision. And I don't particularly think there's anything in principle to make any of that so excessively difficult. It's all a matter of weight And the English courts are very, very used to establishing all of that. And we're certainly seeing more standalone cases brought now, collective ones, rail tickets, and also non-collective ones, whether FX and other cases. So I personally think that issue, whilst no doubt material, tends to be overplayed in its significance and is not in itself a reason for people not to litigate in England if it otherwise makes sense to do it. So that's a sort of a jumbled few reasons why I think the UK might continue to do well, and I'd be very interested in others' views.
Mark, thank you very much. It was anything but jumbled. Fellow panelists, any immediate thoughts or comments on what Mark has said? Carol.
Tim, I'm going to jump in with to endorse his boundless optimism, which I share, Mark. I think you have absolutely identified lots of good reasons why, notwithstanding fierce competition from other jurisdictions, England will remain a really important jurisdiction for these cases. And I think, much as you say, I think the infrastructure point is a really important one in terms of the capacity of the courts and the tribunal to deal with the very complex disclosure and econometric aspects of this, and all the infrastructure that goes around the management of these just massive cases as they make their way through the courts. I'm sure there will be claimants who will be happy to roll the dice, as it were, for a bit of rough justice. They may do well, as Mark, you've identified some of the cases where claimants have done well in sort of quicker and dirtier proceedings than we have here, but not all claimants do succeed in that way. And so some claimants may see that as attractive, but I still think a lot of claimants will value the opportunity for the detailed disclosure and detailed review that they have the opportunity here to make their case and ditto the defendants. So I agree with all that. I also think that what all of these conferences show is that our jurisprudence is really developing, and one of the attractions of our markets is meant to be certainty. And I think as jurisprudence in this area develops further, there will be greater certainty for litigants, and that will remain attractive and continue to attract the work here. So ringing endorsement, Mark, of what you've said.
Tim, if I may, I think at the risk of being in a sort of optimistic echo chamber, I also agree with much of the optimism there. I mean, one other instance, I guess 2 points on the optimistic and slightly question mark as well. On the optimism, one other instance of the use of disclosure, of course, is we've been talking about the increase, or most decisions are now settlement decisions, and we've seen lots of fierce fights about precisely what the scope of those decisions are when they're shorter. And of course, as well as the disclosure that goes to the econometrics that's been mentioned, of course, there's also the disclosure of the commission file. So parties can, of course, argue about the scope of the decision, but one way to seek to cut through that is to obtain disclosure of the 30-odd thousand or so, whatever it is, on the disclosure documents from the commission file, and plead out the claimant's interpretation of the infringement. So again, there's that additional use of disclosure in the English system, which makes it attractive. I guess on the query point, I just think to the extent decisions in the future are not binding, and to the extent there isn't a parallel infringement finding by the CMA or equivalent, just a question mark for funders really, whether the fact of a decision not being binding is just an additional risk factor that they have to consider when standing behind claims. And just for some cases that may just have a dampening effect around the edges and certainly make other jurisdictions more attractive potentially. So that's just a potential question mark against the optimism.
I think that's a fair point, Ed. What I would say is, as you know very well, of course, it hasn't impeded claims being brought, such as rail tickets and others, on a standalone basis. And there could be some flip side advantages, funnily enough. So, for example, in the UK, post end of this year, no need for a stay, even if things are being appealed in Luxembourg. In principle, one could try and persuade the English court to crack on and go all the way through to trial. Just form its own view on the weight to be attached to the content of the commission decision. So, a lot of these things have a countervailing point to play in the balance as well.
Yes, it strikes me that in the truly post-Brexit world, in other words, post all of the transitional provisions and so forth, it does seem pretty likely that an English court would start from the proposition that the Commission decision that is the product of full investigation and is final and binding after any appeals ought to be accorded very great weight. But that doesn't necessarily rule out the possibility that defendants would be able to argue for departure from it, whether in marginal or fundamental respects. But I very much agree with what Mark was just saying. I mean, this will be a factor in the balance, but depending on the nature of the cartel and the decision itself may not be critical at all. Now, I just want to pick up something that Ed was saying, which also is reflected in a very interesting question that has come from one of the participants this afternoon about how the panel may see the future in terms of the role of the CMA alongside the Commission. Because, of course, a lot of the Commission's work has been on truly international cartels, where it has embraced the UK within its EEA-wide market findings. Sometimes these cartels start very far away, like the LCD cartel, which famously started on a golf course in Taiwan. Not something that CMA is likely to investigate. It raises at least a question about where we might find ourselves when the pipeline of cases, which will be binding and do involve the UK, begins to dry up in terms of, if you like, international cartels that have implications for the UK. Anyone want to comment on that?
My overview, for what it's worth, Tim, is I struggle to think if you've got cartel conduct in the future, for example, or abusive conduct, which is global, as many of these cases are, for example, take a typical tech case, or at least EEA-wide, I struggle to think that people will leave their UK portion of damages on the table and just sort of omit it from their recovery strategy. And so I think even in a world where the Commission isn't reaching findings on those things, I can still imagine the decisions being prayed in aid in support of an action in England, which also might, not just seek to recover for UK damages, but the whole shooting match. There being no fundamental problem, of course, with pleading breach of foreign applicable law tort. I think it comes back to the discussion we were just having about the significance of a Commission decision. I agree it will be given quite a lot of weight. I also think whether it's formally binding or non-binding is actually a little bit of a red herring. And the experience of doing these cases, a lot of heat and light is expended on some of these issues. And I'm not sure ultimately where a lot of that will get anybody in terms of the eventual outcome in the cases. These things are going to turn on the economics and the witness evidence in the end. Britain and other cases have shown that. So I personally think that we'll get some CMA decisions in parallel with Commission ones. So you'll be able to sort of combine the two infringement decisions, or pick and choose, or we'll get people bringing their claims anyway, just using the Commission decision for extra evidence and support. But others may feel differently.
I suppose an interesting question is how many of these cases is the CMA actually going to pursue in parallel? And I tend to think, if it's a LIBOR or FX or Google type case, surely that's the sort of thing the CMA is going to be interested in pursuing, both from a policy perspective and because of the impact in the UK specifically. If it's some of these industrial products with the agreement entered into, far away, I just don't know if it's a good use of ultimately UK taxpayers' money for the CMA to be doing a parallel investigation. So it's going to be interesting to see how that plays out. I mean, certainly one thing I have noticed, and it's more on the mergers side, because obviously that's sort of time critical in this run up to Brexit. There, at working level, the communication seems to be really quite effective. So, lots of, oh, have you spoken to the CMA? Oh, CMA pop up, we've heard from the EC that you're about to notify this case. So I suspect there's going to be quite effective cooperation, but of course there is a broader political backdrop to all of this as well. And at the end of the day, if you were the EC, I think it can't be right that through Brexit, the CMA has achieved the ability to strongly influence how the EC runs its own enforcement cases more strongly than it did when the UK was a member of the EC. So there's some kind of interesting tensions there.
There certainly are. Anything else on this before we move on? I see that time is actually ticking away.
Tim, I was just going to add one quick comment about the CMA. I think that there is a big, there is a question about bandwidth for the CMA as it goes into, pursuing potentially subsidy control, additional merger responsibility, all its appeals responsibility and regulation, and now the digital markets unit. But actually coming back to the point made by the rest of the panel about being optimistic, a number of the types of cases that I think we're going to see a lot of in the next few years are abuse of dominance cases, where parties are seeking damages or some sort of rebalancing of the playing field. And the UK there is quite attractive for the disclosure process. So if you need to go off and prove that yourself on a standalone basis, you're going to come to economists like us, and we're going to say to you, well, we need to work out maybe the as efficient competitor sort of framework or standard, which is going to require us to get some access to cost data, or we're going to need to understand a little bit about algorithms that are being used behind the scenes. And without the disclosure process to unlock that and get that information, we can't move forward very effectively. So again, another reason why the sort of wave of cases that might come out of the dominant side, I think favors a system that can handle large amounts of disclosure.
Well, I certainly agree with that. Good, thank you very much. Thank you, Mark, for prompting such an interesting discussion that was optimistic, which is fantastic at the eve of Brexit proper. Now, let's move on, please, to Caroline, who is going to talk about limitation and binding recitals. Caroline.
Thanks, Tim. We've had lots of references to bindingness already, so I think I'll take that first. And if time permits, I will make a very quick reference to limitation, but I'll focus on the question of bindingness. And I think in particular, the bindingness of decisions of EU institutions in the context of English domestic proceedings, which has managed to produce judgments from the CAT, the Court of Appeal and the Supreme Court all in the last 12 months. So it feels like a good topic to take. So we've had 3 judgments this year, which have considered the bindingness of decisions of European institutions in domestic proceedings, but in 2 quite different contexts. First, we've had Servier, and that was the Supreme Court judgment only last month, which considered the issue in the context of annulment decisions by the European courts. And then in Trucks, we've had the CAT decision in March this year, which considered the issue in the context of the bindingness of the Commission decision, where the CAT dealt with bindingness both as a matter of European law and also as a matter of English law principles of abuse of process. And then the Court of Appeal then considered the abuse of process ruling from the CAT in its judgment in Trucks in October this year. Now, both Servier and Trucks engage different aspects of EU law, albeit that they have the same underlying objective of seeking consistency and certainty. Servier, as I said, relates to the annulment by the EU courts of acts of EU institutions in the exercise of powers of judicial review under Article 263 of the Treaty for the Functioning of the European Union, and also the application of Article 266 of the Treaty, which requires an institution whose act has been annulled to take the necessary measures to comply with the annulling judgment. And it is those articles that then give rise to the engagement of the European law principle of res judicata erga omnes. And the purpose of that principle in this context is to preserve the authority of the annulling decision by preventing the court's conclusions on annulment from being undermined, and also to ensure that the EU institution whose decision has been annulled complies with the court direction and is able to do what needs to be done as a matter of EU law. So that's the context in which it arose in Servier. In Trucks, the bindingness of Commission decisions was considered under Article 16 of Regulation 1 of 2003. And that article emphasises the importance of avoiding conflicting decisions to ensure the uniform application of EU competition rules. So Article 16 provides that when national courts rule on agreements, decisions or practices which are already the subject of a Commission decision, they cannot take decisions running counter to the decision adopted by the Commission. So both cases, albeit in different contexts, gave rise to the question of which aspects of the decision in question would be binding, and importantly, for what purpose. So taking Servier first, I should probably start by saying Servier's appeal was rejected by the Supreme Court for entirely different reasons, namely that it was premature. The issue of res judicata erga omnes can't arise because the underlying appeals have not yet run their course. And so that could have been the end of the matter, but the Supreme Court did still consider what the position had been if the appeals had been finally determined, because this raised important issues of law. Importantly, the Supreme Court considered that the principle of res judicata erga omnes applied in the specific context of the annulling decision itself. So in this instance, it was a decision under Article 102 that had been annulled. However, what Servier was seeking to do was to argue that relevant facts as found by the General Court in annulling the Article 102 decision should be applied in a wholly different context, namely the issue of mitigation and causation in an Article 101 domestic damages case. And the Supreme Court held that the findings on which Servier wanted to rely had no significance independent of the annulling judgment. It wasn't necessary to treat those findings as binding in any other legal context in order to preserve the authority of the annulling judgment. And so for that reason, the findings would not be binding in the context of the 101 domestic damages case. So Servier's appeal failed for that reason too. But the court did also confirm that if the General Court's decision on which Servier wished to rely had become final, and if the question had arisen in the context of a 102 case and not a 101 case, then the four propositions of fact which Servier was seeking to rely on wouldn't be capable of challenge in the domestic courts if they comprised an essential basis of the General Court's ruling. So effectively, the Supreme Court has confirmed the essential basis test in that context. Then in Trucks, we saw the same thing. The issue arose under Article 16, as I said, and the tribunal confirmed in that context too that the test is one of essential basis. The CAT found the principles which determine whether a finding in a recital to a decision is susceptible of challenge before the EU courts are appropriately applicable to determine whether a finding is binding for the purposes of Article 16. So therefore you have to consider, is the recital an essential basis or the necessary support for the determination in the operative part, or is it necessary to understand the scope of the operative part? So the principle, I think we can say, is now completely clear in both cases in terms of the test to be applied. But what's also clear from the judgments we've had is that the exercise to identify what has actually been decided, either in the operative part, which is to be interpreted by the aid of the recitals, or in a recital, which is an essential basis or provides the necessary support, is highly fact-specific. In Servier, because of its rejection of the appeal on other grounds, the Supreme Court didn't have to undertake the exercise of identifying which of the propositions would be binding for these purposes, applying the essential basis test. But the Supreme Court rather wisely recognised that there will be frequently a number of facts found by the General Court to support a particular conclusion. And national courts are likely to experience difficulty in deciding which are essential or inseparable from or sufficiently proximate to the ratio of the decision. So there is considerable scope for different national courts to come to different conclusions as to which findings are binding. So what we have is, in the search for consistency, an express recognition that inconsistency may well arise. And I think the detailed analysis undertaken by the CAT in the Trucks case and the conclusions that the CAT reached there well demonstrate the difficulties. The claimants said all the recitals were binding. The defendants said very few were. And what the tribunal said was somewhere in between, although Ed may disagree with me, not in the middle, and much closer to the defendants, although possibly I would say that, wouldn't I? But the essential basis was effectively pretty narrowly construed. But what it does do is it makes it very difficult to predict, particularly whereas in trucks, the CAT actually paraphrased some of the recitals to capture the essential basis. And Servier had done the same in advancing the propositions that it said were binding. What the CAT expressly said that in considering what the essential basis is, in some respects, that question falls to be answered by reading several recitals together, and they do not always have to be read literally. So I think what that means is there is it's very difficult to predict how courts and tribunals who are asked to undertake this detailed analysis, which the Court of Appeal described as a sifting of facts, will apply the test when they're faced with it. So that's where I think we've ended up on bindingness as a matter of EU law after these various decisions. However, as has already been mentioned, in the trucks case, the position was also analysed by the CAT and then the Court of Appeal in terms of English law abuse of process principles. Both the CAT and the Court of Appeal found that it would be an abuse of process under English law principles for addressees of a settlement decision to seek to resile from facts which have been accepted as part of the settlement, subsequently in domestic damages proceedings. So notwithstanding that many of the facts in the Commission's decision on trucks wouldn't be binding on the tribunal under Article 16, the defendants would nevertheless be bound not to dispute them in damages proceedings in the English courts. Now, I won't be able to do justice to either judgment in the time available. I'm very conscious of time. But I think it's worth pausing here to consider what the actual impact of the doctrine of abuse might have in domestic proceedings. And we've already had a couple of references to this. First of all, the very good question of whether, in fact, in the context of settlement, when parties are now considering entering into settlements with the Commission, or indeed the CMA, whether this will be a factor that is taken into account in deciding whether or not to enter into an agreement or a settlement decision in circumstances in which, as we all know, the ability to actually negotiate the terms of that are pretty narrow. So I think there's a question as to how that's actually going to play out. We've also had reference to the question of the bindingness of European Commission decisions post-Brexit. Well, this is the application of an English law principle of abuse of process, not dependent really on European principles. And so if you enter into a settlement decision, if you enter into a settlement with the Commission, even if it's not binding under Article 16, the abuse of process principles will still bind you to the facts in that decision, I think, even after Brexit. So I think those are important considerations. Mark either stole my thunder or rained on my parade. I can't quite decide which, when he referred to the heat and light around these debates of whether something is binding and how much it really matters. And I think that's a very fair point to raise. It's important to note what the boundaries of this decision. It is confined to settlement decisions, and so it doesn't have wider application effectively, so it is limited to settlement. Second, since it is only an issue which arises in settlement decisions, those decisions tend to be highly summarised and generalised. So I think it really does remain to be seen how far reliance on these highly summarised and generalised settlement decisions will really take claimants in the context of the very detailed factual examination which will inevitably occur at the trial of a claim for damages. And certainly when you have a decision that relates to an infringement by object rather than effects, those findings are likely to be of limited relevance to the issues which the domestic court has to determine, which is very much focused on causation and loss. Also probably just worth mentioning that the CAT did identify certain exceptions that would apply where it wouldn't be an abusive process for defendants to seek to resile. So there are ways in which, even in a settlement decision, not every finding of fact will necessarily be binding. And I think finally, and I think this again goes to Mark's point, many of the facts referred to in the decision, in the trucks case, but also more generally, had already been pleaded to and admitted as part of the pleadings process. And it was also readily accepted that all of the facts would in any event be admissible in the proceedings, even if they're not strictly binding. So probably a question as to how far the abuse of process ruling will really have practical implications. And obviously that's something that we will closely monitor as these cases unfold. That was all I was going to say on that. Tim, I'm conscious of time. I will just mention limitation simply to say that there was a decision earlier this year in the case of Granville and Infineon relating to limitation. It doesn't really create any new law, but it was quite interesting to see a good illustration of the detailed factual analysis which may be necessary to determine what a claimant did or didn't know or should have known, and whether such knowledge was sufficient to enable it to plead a claim against the defendants prior to the publication of a commission decision in the context of deciding when the limitation period started to run or not in a deliberate concealment case. So that, I think Mark may be able to correct me on this, but I think that's subject to an appeal that will be heard next year. So probably best just to leave that as a little teaser for next year's conference, and something we'll be able to talk about then once that appeal has been determined.
Fantastic. Thank you, Caroline. All of that was tremendously interesting. Any members of the panel like to comment on either of those issues? Well, Mark, yes.
I think I was maybe just going to apologise for stealing thunder or raining on parades, which is not my intention. And I think my remarks reflected a sort of defence side perspective on what else are we going to say in the wake of all of those rulings, other than that too much emphasis is placed on the point and none of it's determinative. And I sort of I'm sure there's a sort of equal and opposite claimant side view that continues to attach great significance to those binding recitals judgments and the abuse of process doctrine. And probably still hold the contrary view to the one that you and I have, Caroline.
Exactly.
Well, I will just venture to put a bit of claimant perspective on this, as I'm on the other side from Caroline on precisely this issue. And I suppose the claimant perspective is claimants tend to mention asymmetry of information about every 10 minutes in a cartel case. And where there are findings or admissions, and the admissions have been made in exchange for a discount, claimants are understandably quite keen to get whatever benefit they can from them, even recognising, as Caroline rightly says, ultimately these are causation and quantum cases. She and I were both in court when a particular High Court judge said, why do you need disclosure at all? This case is just going to be on econometrics. But not all courts think that way, and not all trials turn out that way. Now, anything else on this topic? I don't want to sound like I'm rushing people along, but we have 25 minutes left and two more really excellent speakers to hear from. No, okay, well, thank you very much, Caroline. And that does take us to Ed, who, like me, is on the other side in trucks. And I hope he at least will agree with what I just said from the claimant perspective. And Ed's going to talk principally about issues of case management and some issues surrounding the vexed question of pass on. Ed.
Yes, that's right. And I was resisting in the time available getting into a fully fledged debate on the abuse of process judgment. No, thank you, Tim. Yes, I wanted to talk about two aspects of the Supreme Court's judgment. One of which is pass on, which Mark Brearley mentioned earlier on, and the second, which is a lower key but important aspect that wasn't mentioned earlier on, is the one of case management and how that's also had an immediate impact. So on pass on, well, I'll kick off there. I guess the Supreme Court's judgment gives two important clarifications. The first is the broad axe. The Supreme Court made clear that a defendant is not required to provide a greater degree of precision in the quantification of pass on than the precision required for claimants to prove overcharge. So the broad axe applies to both overcharge and pass on. And the second is that pass on is a form of mitigation. Nothing particularly controversial in those principles now confirmed by the Supreme Court. However, and as I'll come on to, there does remain significant debate between litigating parties as to the application of those principles. And I think really the debate relates to the following two important factors from the Supreme Court judgment. The first factor is the two ways to pass on analysis. So the Supreme Court set out which of the four reactions the merchant claimants had to a higher input cost may be considered as pass on. Where a merchant has done nothing in response to a higher cost, option 1, or has responded by cost cutting internally on discretionary spend, like cutting its marketing budget, option 2, then the merchant is not considered to have passed on costs, and it can claim the full amount of the overcharge. However, where a merchant has sought to reduce its costs by negotiation with other suppliers, what's referred to as option 3, or where the merchant has increased prices to its customers, option 4, then they can be passed on. And I'll come back to that in a moment. The second factor, which is causing debate, is the legal causation for mitigation. And this was an issue which I'll explain now was taken as read by the Supreme Court in this case. The Supreme Court said that the issue of mitigation which arose was whether in fact the merchants had avoided all or part of their losses. And the Supreme Court endorsed the following principle stated in British Westinghouse, which said that when in the course of his business the claimant has taken action arising out of the transaction, which action has diminished his loss, the effect in actual diminution of loss he has suffered may be taken into account. The Supreme Court emphasised that the question of legal or proximate causation arises when considering the issue of mitigation. And the Supreme Court underlined that the mitigation action taken by the claimant needs to arise out of the original transaction. However, the Supreme Court didn't actually need to examine that any further, as they were very clear that the question of legal causation is straightforward in the context of a retail business in which the merchant seeks to recover its costs in annual or other regular budgeting. So using the broad axe principle, it was therefore in this case a question on the facts of estimation of the extent to which a merchant utilised each of those 4 reaction options outlined above, and quantifying the amounts for the 2 options which are allowed as pass on, namely negotiation with other suppliers and price increases to customers. So what about other cases? How should the courts or the tribunal assess legal causation for mitigation in circumstances where the claimants are not retail businesses and when the claimants are not seeking to recover costs in regular budgeting, like the merchants in this case? For example, what about where the cartelised input is a de minimis input cost to a much wider business, and where the product or service sold by the business does not itself directly incorporate the cartelised input? So the point is really that legal causation or mitigation and pass-on cannot be taken as read in other cases. And what about that other factor, or particular factor of pass-on through negotiation with other suppliers? Here, this was considered a potential form of pass-on the facts of retail businesses seeking to recover costs in regular budgeting. But is this actually confined to the facts, or is it a broader statement of the law? There are debates about the application of this to different facts, not least given the implications for disclosure and expert evidence that flow from it. For example, in many scenarios, it will not at all be evident on the face of it whether a business negotiates to reduce the prices it pays suppliers A, B, and C when it faces higher prices from supplier D. For example, let's take our classic widget manufacturer facing higher prices, and let's say the higher prices are coming for staff health and safety equipment. Will that manufacturer negotiate lower prices for its raw metal, or its electricity supply, or its trade press adverts, or its executive company cars as a result of health and safety price increases? So what are the implications? Without any factual basis, a defendant may simply be asserting a legal principle of mitigation through negotiation with other suppliers. And disclosure based on that assertion could be vast, a costly fishing expedition, potentially looking at costs and negotiations with hundreds of suppliers over many, many years. So will the courts allow it? What are the limits in practice to seeking to establish pass-on through negotiation with other suppliers? So that's the pass-on points I wanted to pick up. And I'll just turn now to case management and pause there. But Mr. Justice Ross mentioned earlier the huge challenges of having multiple claims. And at the very end of its judgment, the Supreme Court unexpectedly made some very broad comments about case management, which have immediately had an impact on the trucks litigation in this jurisdiction. And it will also have an impact on all future follow-on litigation in the UK when there are multiple claims arising from the same infringement, which obviously happens now with most infringements in practice. As we all know, that in interchange, different courts heard different cases and reached inconsistent judgments. And there were numerous claims kicking around and remain kicking around as like in trucks. And the concern has frequently been raised in trucks that we must avoid another interchange, i.e. avoid inconsistent judgments and the potential for appeals that comes from that. And of course, separate from all issues of inconsistency, there's a very real and sensible consideration that needs to be given in any court system to how you move multiple claims through a system. So case management issues reached somewhat of a crescendo this October in the trucks claims. And the Supreme Court Sainsbury's judgment has influenced the direction taken. So, as many of you will know, since about 2018, the first wave of trucks claims in the UK has been case managed together at a series of CMCs addressing common issues. And again, Mr. Justice Roth referred earlier to the specialist case management panel that's been hearing all that first wave together. However, until now, no single claim or subgroup of claims has been released to progress to trial. So this October CMC just passed became a bit of a focal point of whether, and if so, how to progress the trucks claims towards trial. And the CAT had a full spectrum of options before it, like on most issues from the parties. On the one hand, there was the position of let all cases progress individually, through to the other end of the spectrum, with some arguing that the tribunal should actually pause all cases pending the limitation period expiring, and then manage all cases issued by that point as one single cohort. On the one hand, the claimants argued that it was unjust to be forced to litigate opposite defendants they had never sued, and alongside claimants they had not chosen to join up with. On the other hand, the defendants argued about the perils of inconsistent judgments and the burden of fighting so many cases. So what was the Supreme Court's view in Sainsbury's on these sorts of issues? Well, at the end of its judgment, as I mentioned, it's only a few paragraphs. The Supreme Court was very clear in its view of the principles that applied. The Supreme Court said that in the adversarial system of litigation in this country, the task of the courts is to do justice between the parties in relation to the way in which they have framed and prosecuted their respective cases, rather than to carry out some wider inquisitorial function as a searcher after truth. The Supreme Court noted there are many pending interchange claims and it would be impracticable to hear them together. And it noted that, and in noting that there have been separate interchange determinations to date, taking place in different courts with different results, the Supreme Court actually rejected any suggestion that things had gone wrong. On the contrary, the Supreme Court said that there had been no procedural mishap, and rather this was a fair situation arising from deliberate and informed choices made by the parties and the courts as to how these complex claims should progress. So back in trucks with those words in mind, what actually happened? Well, the first wave was indeed broken up in order to progress to trial in 3 separate subgroups. Trial 1 is Royal Mail and BT's claims against DAF, jointly case managed to a joint trial on all issues in April 22. Trial 2 is Dawson Group and Riders claims, listed for a trial in March 23, and Trial 3 is the VFW claimants on a date to be confirmed likely 24. And the CAT took head-on the issue of potential inconsistent judgments in making that ruling. It explained that each of the 3 trials will be heard by a different panel, and the CAT said that with this many claims and many more to come, the potential for inconsistent judgments was inescapable. On the burden for defendants, the CAT appreciated that the defendants' experts would appear in several trials on the same or similar issues, but said that with a cartel of this magnitude, that's a price they think had to be paid by the defendants. And indeed, the CAT was even more positive in a sense by saying that they saw actually some inherent advantages to all cases by proceeding in this way, as they advocated that completing trials and producing judgments will have benefits for all other claims, as although not binding, they will facilitate progress in those claims and ultimately settlement. So very briefly to wrap up and looking ahead more broadly than interchange in trucks, there is now, and as of this autumn, a much clearer picture on how multiple claims arising from the same infringement will be managed by the English court system in the future. Individual claims will progress, and they may do so on their own or sensibly in joint case management with others in subgroups, if you like. This may involve some sensible interviewing groupings around common issues, but ultimately claimants won't be required to wait till the end, if you like, for some sort of mass Uber trial. And there is a sort of logic to that, really, when you consider that we also have, as discussed, a collective action system. That is the place for a trial of multiple claims together. And claimants who pursue claims outside of that system, who are generally corporate claimants with large claims, should have the freedom to pursue their claims within reasonable case management bounds. So I'll pause there, Tim, on those 2 points.
Thank you very much. That is fascinating stuff. Any questions or comments or thoughts from the panel? Grant.
Yes, Tim, I could use some comments on Ed's discussion on Sainsbury's to kick off some of my comments on the role of experts and what we learned this year. Well, I think, there have been a few key decisions that I'd recommend people taking a look at for 2020. The Sainsbury's decision obviously sets out some interesting new battlegrounds. As Ed mentioned, it sort of opens up potentially large areas of disclosure required from claimants, and that's going to complicate the lives of many different claims and collective actions that involve businesses. I'd recommend everybody takes a look, if you're an economic expert or expert in general, back at the disclosure ruling that the CAT made in trucks all the way towards the beginning of the year. It's, talks about the broad axe and the fact that estimates will be averages and extrapolations and that, but they still don't want economists wielding the broad axe. We're still expected to be very, very precise and proportionate on what data that we ask for. And it's an interesting ruling to read because it really focuses on proportionality, and that sometimes you may want certain data, you may want to try certain different techniques, but out of proportionality, those won't be offered to the expert. But the question is, does the expert still ask for it? And unfortunately, I'll come to that towards the end. Us experts will keep asking for that data, just to make sure we've explored all the different routes that may be relevant. And it is, important in econometrics to get things accurate, because even small changes to the data set, even small changes to the model can move things around like a broad axe, very, very substantially. Sainsbury's is, as Ed mentioned, very important for thinking through next steps. I particularly took away some of the comments that are important in Sainsbury's around estimating the volume effects. And I think that that's going to be a big debate area in the next few years. People might put more time and energy into working out exactly how much pass on there was, but at the same time, tried to work harder to demonstrate that they lost some additional sales. So I think there'll be further disclosure needed on changes in cost base and economies of scale over time. And then the other two places that I think we're going to be paying a lot of attention is firstly, obviously at the end of this week, the Supreme Court will hand down its judgment as to what threshold to set in collective actions. And for experts, if it ends up at the CAT side of the equation, that's going to be a lot of work being done right up front to make sure that the analysis is right and shows absolutely everything working before getting certification. But on the other hand, if it's a low threshold, then there's going to be this race between different potential CPO representatives, and it could well come down to the experts having to demonstrate that they've got a particularly dynamic, interesting, or important methodology to estimate things for that CPO to be chosen ahead of others. So I think that's going to put a lot of pressure on the experts to bring forward in time the analysis that they do in collective actions. And that'll be a big part of next year. Briefly, right towards the end of last year, but affecting a lot of our thinking as economists this year, there was the Royal Mail Ofcom CAT decision, which involved AEC tests. I won't go into it now, but that's an area which will continue to develop with Intel, and I can even do an advert and say that tomorrow they're going to do a dominant session which will go into AEC tests and what that means. So that might be a worthwhile thing to attend. Finally, I'm going to make two other quick comments. Firstly, as an expert, we take very seriously the statement of truth that we have to put in at the back of the report. It's the thing that says that we have, just done our duty to the court, not necessarily to any individual client. We've represented the evidence that we've looked at in a truthful way. And I think it's worth just flagging for all the experts that this year in October, the statement of truth was amended in the CPR rules and puts just a little bit more pressure on experts to get it right. We now include a sentence talking about recognizing that there could be a contempt of court if we are putting in something that we can't justify as truthful, or might be not our opinion or following the evidence. And that's important because experts can be sent off, according to the Court of Appeal judgment late last year, for a year in jail if we get it wrong. So that's one of the reasons why in the disclosure stage, we care so much about asking all the right questions to make sure that we've pursued everything. It also might be why when all of the instructing solicitors are wondering why the experts are spending that little more time in their expert reports being careful, it's because we don't want sort of an error in a spreadsheet cell to end us in a jail cell. And then on a slightly more serious and somber note, something that Mark's actually picked up on already, I think that we have to reflect on, this year is going to have a big impact due to the pandemic on the future of competition litigation work. And, we should firstly, respectfully acknowledge that given the scale of the tragedy for everybody this year, thinking about the impacts on competition litigation is just a tiny part of the story. But I will say, Mark's mentioned crisis cartels, that could well be a factor. We have seen competition authorities sort of distracted into looking more at excessive pricing cases. But how to treat, the last 9 months of shock is going to be a huge part of thinking about expert work in litigation going forward. For cartels coming through, there's going to be a question about whether we can use, this last year as a comparable period, a normal period, whether markets have changed so radically or consumer behavior has changed so radically before and after coronavirus in a particular market, that data on either side of it can be used as a meaningful comparator. So unfortunately, I think we'll be spending a lot of time in the next 10 years talking about, or having experts in hot tubs talking about how to treat the last 9 months of shock for so many markets and so many people. So let me stop there and hand back to you.
Thank you very much, Grant. Very interesting and thought-provoking. We have just a few minutes left. Any thoughts or comments from others on the panel about the points we've just heard? Anybody? Well,
Just one thing I was going to mention is I agree with what Graham was saying. In one sense, we'd all just sort of swerved or avoided what would have been an interesting trial on some of these issues, which would have been the power cables one, post-BritNed, the National Grid claim, which obviously settled just before trial. And that would have been interesting because it was actually quite a different series of claims in the BritNed one. It wasn't a single big project, it was many different projects, and there would have been more of an emphasis on econometrics. And it would have been very interesting, I think, to see how the tribunal grappled with that in light of the BritNed precedent. And I think would have been quite an interesting bellwether for future cases as well. But we'll never know now, given that the case settled, and I guess we'll have to wait for the next one to come along and raise similar issues.
Yes, and if I can echo something that was said earlier, it really strikes me listening to the whole range of views and issues raised this afternoon. We're now a long way, 20 years into the Competition Act. We've had a whole series now of leading judgments on key issues, yet so much remains unresolved. And thinking about the Sainsbury's judgment on pass-on, as Ed says, a key part of it is to equate pass-on with mitigation, taking us back to British Westinghouse, which is, of course, an ancient common law authority that has been revisited over the years by the courts. But we're still left with really serious uncertainty about what the test for causation might mean in practice. And as Caroline says, the question of what is a binding recital, we know the answer is a level of abstraction, but we really don't know how that will play out in different cases. And indeed, in the trust case, it was heavily contested. So we all, I think, in the competition law industry, greet these leading judgments greedily, actually, for the light that they shed. but it is remarkable actually how much there remains unresolved. And that, of course, is just an issue that raises litigation risk for both sides. And as someone who wasn't involved in power cables, that may well be why that one did settle at the door of the court. Mark can't say, and we'll never know. So anything else anyone would like to add before I just wrap up? No, good. Well, thank you to all of our panelists. This has been fantastic. Thank you also to the audience who've listened, and indeed for the questions, some of which we've been able to deal with, but not all. It really has been a fascinating afternoon and bodes well for another year with some major interest and challenge in this sector. Not just Brexit, not just coronavirus, which of course competition law may be the least important thing affected by coronavirus, but also the very intriguing digital market unit that was asking for the power to levy 10% fines today. So interesting times ahead. Thank you all very much indeed. I'm sorry we can't have the traditional round of applause other than virtually and in the privacy of people's own homes and offices. But with that, I will hand back to Pam. Thank you.